All right, picking back up. The next half is going to be talking primarily about exceptions to IP protections, either licenses that allow you to use copyrighted content without having to ask permission, or fair use doctrine. So the two or three rather learning objectives in this part are being able to describe the fair use doctrine, list at least one goal of open source software, and describe a purpose of the Creative Commons license. So the first thing we'll talk about is fair use. It's a particularly important area in terms of how we can use content or copyrighted content that's been created, especially when we know that copyright protections come into being for a particular piece of content essentially at creation time. So the moment you create something, it becomes you then own the copyright on it. So how do we use content, make use of existing content in a legal way? And this is where fair use comes in. So the concept behind fair use is that it's sometimes legal to reproduce a copyrighted work without permission under the fair use doctrine, where the fair use doctrine allows uses that contribute to new work and critically are not likely to deprive authors of income from their existing work. So there are four main factors that determine whether something is fair use. This is the purpose and nature of the use of the art, the nature of the copyrighted work, the amount and the significance of the portion used, and the effects of the use on the value of the copyrighted work. And there are a bunch of examples of this. So for a number of examples where the courts have specifically considered and allowed fair use of content. So there, some examples are Google and the use of TVIs to make information searchable. So all the titles and descriptions of television shows are in some sense copyrighted, but Google aggregates all of these and makes them searchable. Now, by providing a search interface for these pieces of TV information, you're not detracting from the original creator's use of the idea. So that episode of Friends where they went to the coffee shop, if I show you, okay, it is this episode that plays at this time on this station, that doesn't remove you or remove any sort of profit from the content creator. The New York Times is allowed to quote and reprint in order to report the news. This is definitely a good instance of fair use, where if a journalistic organization wants to reprint information, either an image or a part of a speech or part of a sports game, and they're doing it for the news, well, you're consuming the news not necessarily to remove the profit motivation from or impede upon the profit of the original creator. You're not producing the whole work, you are producing parts of it for the public good. Same thing with Braille. So while J.K. Rowling may make all of her Harry Potter books available, but they're copyrighted, somebody can then take these books and make them accessible to the blind by adding Braille or creating Braille versions of them, and that's been considered fair use, because again, you're trying to make the content more accessible. Copying parts of a computer program to make new programs that engage with it or that interact with that code is considered fair use. It's a particularly important thing for things like APIs. So you could reverse engineer a copyrighted API or a non-published API to make new pieces of software that work with that API. That's considered fair use. So we've seen this before with, say you buy a computer game that requires some licensing, some DMCA-based licensing mechanism that requires your computer to report back to some server somewhere that the developer controls. But when the developer turns that DMCA server off, how are you allowed to use this program, or how can you use a program that you've purchased? So by reverse engineering the server and then making software that works with it that allows you to continue to use the program, that's considered fair use, or a good example of that. South Park has made a lot of use of fair use by being able to make fun of culture or parody. Examples of using old versions of art or existing art to make new art, as with Andy Warhol's fair use. Time shifting, which we'll talk about in a few minutes, being able to record shows and watch them later in your own home is considered fair use, because you're not trying to take away profit from somebody else. You're just making things more convenient for yourself. and then being able to reproduce logos for history or for historical reasons or in educational books on design, these kinds of things could also be considered fair use. So there are many examples here, and there are a number of organizations that are devoted to educating people about fair use. There's one group in society that considers fair use to be a fundamental right. There is an existing set of content out there that you can use basically without restriction, as long as you're using it for specific reasons, like education. This has been upheld by the Supreme Court, with Justice Ruth Bader Ginsburg talking about fair use as being a First Amendment safeguard. And this makes sense, right? So if fair use was not an allowable doctrine, then I could squash a lot of free speech by claiming, oh, this is you're making use of a copyrighted statement of mine. And news organizations wouldn't be able to publish things. People wouldn't be able to quote other people. All kinds of difficulties would come about. But also fair use is important to the economy. So this one group from CCIA, net.org, has talked about how 17% of the economy relies on fair use, which is larger than manufacturing, retail, and agriculture in the United States. It's actually a lot of technology relies on being able to reuse existing concepts and existing techniques, and television shows like The Daily Show or Last Week Tonight likely wouldn't exist without the protections for parody that come from the fair use doctrine. So we can talk about a specific example of this that changed how we engage with media. So this is called a Sony Betamax VCR. Maybe you've heard of this. It's not Baymax from Big Hero 6. It's the Betamax. It was introduced in 1975, but a very important part of the capabilities of this device was the ability to record shows from your television. This is essentially very early technology, or very early conceptual technology underlying the TiVo, where you can record shows and watch later, or any DVR. So the Betamax VCR allowed viewers to record a show and watch that show later. So this became time shifting in legal parlance. This idea that I can take a show that's broadcast at a particular time and shift it to watch at a later time. Now, after Sony introduced this technology to the public, a number of movie studios then tried to sue, especially Universal City Studios, suing Sony for enabling copyright infringement of their material. Essentially, Universal Studios owned a movie that was then played over the television airwaves, and since they have a copyright on the movie, and that copyright gives them the right to control how their content is reproduced, then by enabling consumers to reproduce content essentially without permission, Sony is ostensibly incentivizing or providing a mechanism for people to violate the Universal City Studios copyright en masse. Now, this is in some sense a good example of Universal Studios or a motion picture company being the villain here, but they had a point about how this is violating the ability to control how their content gets reproduced, which is why you have one of the reasons why you have a copyright in the first place. Fortunately, Mr. Rogers, when this lawsuit between Sony and Universal Studios went to the Supreme Court, Mr. Rogers went and testified about the importance of the VCR and being able to time shift shows, especially his show, which was extremely popular, where people could watch his show, or rather record his show when it was broadcast, and parents could watch it with their children at a later time, or rewatch it at some other point in the future. Mr. Rogers was a big proponent of this, about the educational value that it provided. The idea was that you could take a show that was broadcast at a particular time, record it, hold on to it, and watch it later within the comfort of your own home. And that was considered fair use. But if you were to record it, hold it, and then do a commercial showing or a public showing, or showing it to a bunch of friends and charging admission, that was not considered fair use. So this aspect of watching it later within your own home was a key point in being able to convince the Supreme Court that this example of time shifting was fair use. So now we can do this with a number of, or this is since, this idea of time shifting has since been expanded to this idea of space shifting, where you have a particular piece of content, say a CD or a vinyl record, you can put it on your stereo and you can copy it so you can watch it or engage with it in other ways. So you can't fit a record into a Walkman. All this is super anachronistic, I understand, but the idea was it might be more convenient for you to take a version of a piece of sound that you have, copy it to another device that you also have, and then be able to enjoy that particular piece of content on any number of your devices. This is also considered fair use. You're shifting the space in which you enjoy it. But critically, the moment you give one of these copies to your friend, this is not fair use. So this lawsuit between Sony and Universal City Studios made it all the way to the Supreme Court, where it was ruled upon in 1984. The Supreme Court essentially said that this time shifting is considered fair use, and this has become one of the most influential mechanisms for testing whether an individual is liable for damages caused to an organization by recording content. This has been hugely impactful from the standpoint of content creation. But fair use applies in other places as well. So you may think that if you have two different songs and you take different constituent parts of these songs and put them together, for instance, the instrumental track from one song and the vocal track from another song, and put them together to create new art, this might be considered fair use under the creation of new art mechanism. Similarly, to a degree, you can take an audio collage where if you have you create a new composition from many pieces of existing audio fragments to create something new. Now, you might ask, are both of these fair use for this, and are they fair use for the same reason? Well, it turns out audio collages are considered fair use. So we're talking about many different pieces of audio being put together to create something new. But these single or small track mashups are not considered fair use, unless they're for a particular reason like criticism, satire, or parody. And to some degree this makes sense, right? Because if I am taking two pieces of music and mashing them together, in theory I'm creating a new piece of music that might detract from the profit value from the original creators, because these three pieces of music, the two originals and the mashup, may all compete for the same space, especially on radio airwaves or something like that. Whereas an audio collage of many different pieces are unlikely to compete with the original composition. So the mashups are only allowed if they are meant to not compete, that is, because they're pieces of criticism, satire, or parody. So there's some nuance here. Same thing with the amount of reuse and the reason. So this idea of if you're using criticism, or if you're using material to criticize something or to parody something, oftentimes this tends to be or ends up being fair use. So if I take a still from a football game or baseball game and use it to talk about how terrible umpires are, or how a particular call was completely missed, this is generally going to be considered fair use because I'm reporting on something and I'm not detracting from the original work. Same thing if I take an existing copyrighted piece of work and parody it for whatever reason, either political satire or political parody, this is also considered, or tends to be considered, fair use. And there are a number of other cases here, too many to get into, but I'll let this be a discussion question for you. Okay, so the fair use doctrine is a way to use content without asking for permission. But what if we want to do something else? What if I, the content creator, want to make it clear that a particular piece of content or a particular piece of software that I develop should be available for people to use without permission? But I can't just do so in a way that is extremely open. I can't do so in a way that says, all right, everybody can use this, and still prevent some other organization from taking the piece of software that I've created and then using it for their own ends and not crediting me or making money off my invention or my piece of software. So how do I allow people to use my software without consent, but also maintain some amount of control about what is allowable use? So this is where the idea of open source software and open source licensing comes in. So you might ask, well, why does this matter? Well, open source software has this, on the one hand, it has a pragmatic aspect to it, and on the other hand, it has a philosophical aspect to it. So from the pragmatic standpoint, we'll talk about some of the criticisms of proprietary software and the existing copyright protection mechanism that's out there. For one, a couple years ago, a woman was ordered to pay $222,000 to the RIAA from a lawsuit involving 24 songs. So this is a huge amount of money. We're talking about $10,000 or so per song, because she had shared this music on some file sharing site. So this is a pretty significant fine, and $222,000 was much lower than what the RIAA originally wanted, which is in the millions of dollars. So there's a pretty strong criticism here that this is a really harsh measure in terms of like cruel and unusual punishment for sharing a piece of content, given how easy it is to share content. Likewise, there's been a lot of concern and criticism against organizations like YouTube in allowing people to abuse copyright claims. So the Digital Millennium Copyright Act allows people to say, if you have a piece of content that violates my copyright, I have to be able to, I should be allowed to tell you, and then you need to take that content down. But oftentimes this especially in YouTube, this mechanism gets used to enforce takedowns, or it gets used in an incorrect way, where even if I use something that's fair use, or in a way that's consistent with the fair use doctrine, YouTube might automatically take it down, especially if it's something like you might imagine that somebody who is particularly sensitive to criticism may go to YouTube and file a copyright claim against a piece or a video that I'm using to criticize them if I'm using some piece of content of theirs. So enforcing copyright becomes difficult and ends up being rife for abuse, especially in these online ecosystems where democratization of content means that there's just way too much content for individual people to evaluate. So you end up having to rely on these automated systems that don't have or can't deal with the nuance of fair use. And then you may have heard of patent trolls as well, where people are buying patents and then using those patents to extort money from other organizations or other companies. And then just all they do is make money by sitting on patents. And this is not at all what the purpose of the patent system or intellectual property was supposed to do. So all of this really is reducing the amount of innovation and new creation that's going on, which is not at all the principle behind providing intellectual property. So then, as I mentioned, there's the pragmatic view and there's the philosophical view, where some people ask, is it even okay to allow someone to own a piece of intellectual property? Philosophically, what does this mean? So I won't engage as much with that question. But it is an argument that people make, based on this idea that mining gems and ore makes sense in a tangible way, whereas mining words does not. So all this transformation aspect still holds, but when you are mining ideas or mining different pieces of syntax and code and putting them together, what does this mean really for ownership? So this philosophical perspective has a number of major proponents, one of which is Richard Stallman, and a number of other people who are luminaries in the open source movement, as evidenced by this serious discussion by XKCD here, talking about the existing sort of conflict between organizations like Microsoft that are essentially closed source and organizations like the Open Source Software Foundation or the Free Software Foundation, and Richard Stallman's general public license. So open source software came about to address these sort of issues, both from a pragmatic standpoint and from a philosophical standpoint. That basically there should be a way for an author to say, no, there are no restrictions preventing other people from selling or giving away, or there should be no restrictions on an author from saying, you can sell or give away my software. So source code has to be included in the distribution for it to be open source. So anybody can then not just get access to my software. So it's not just freeware, but it's open source in that the underlying source code that is necessary to build my software is also free and freely available. And there are no restrictions on preventing people from modifying my source code. So I've made my source code available. Anybody can take the source code that I have created and modify it to their heart's content, subject to some restrictions about can they monetize it or claim it's their own. And again, there are no restrictions regarding how people can use the software. So if I create software that's used for time-shifting videos, and then it gets used to, that software gets used to create new art for videos or something like that, there should be no restrictions there either. And then the same rights apply to everyone, including the people who redistribute my software. So I create this piece of software, I make it open source. Anybody who then takes it and redistributes it also get the same rights to that, to their modified version or their modified and redistributed version of my software. So there's some nice consequences that come out from this, that since everybody has access to the software, if there's a particular bug that somebody finds, the community can then engage and address this bug. Or if I, as the original developer, get bored with the project or pass away, it doesn't mean that the project dies. The community can still be involved in improving the work. As a corollary to this, since there are more people who could engage with the work, then new versions of the programs could appear faster or more frequently because more people are working on it. And it addresses this conflict between we need to obey the law and the protections given by or given to intellectual property and the moral and ethical obligations we have to helping others. So you could imagine if I created a piece of software that did modeling for epidemics, then I could make it open source and still allow people to redistribute it, use it, and modify it as they see fit, because not all pandemics are the same, and maybe it needs to be modified for specific geographic areas. I can, as the content creator, use one of these open source licenses and allow people, from a legal perspective, to reuse it and benefit from it without having to ask me for permission. So then all these programs belong not just to an individual, but to an entire community of people. And we get to move away from who owns the original source code to people being able to provide service for a particular piece of software. And the value that I get isn't from the idea and control over the idea, but from the service I can provide you in helping you use the idea or providing support and using the technology. So there are a bunch of examples. Bind is is one of the major pieces of software that runs domain name resolution in the internet. Apache, the Apache Software Foundation, owns a lot of software, from web servers to big machine learning systems. SendMail is a major underlying mail client for email. The Android operating system that comes on Google's phones, so Android is based on Linux and is itself an open source operating system. Firefox and Chrome are both open source, Chromium to a degree. OpenOffice, as a free replacement for things like Microsoft Office, is also free and open source. A number of very popular languages are free and open source, as are a number of compilers. So OpenOffice by Apache has a lot of open source credentials and credibility for making a lot of this content or a lot of this technology available, and people can modify it as they see fit. And the GNU project in Linux was started in the early 80s as a way to provide an open source alternative to to the closed source Unix operating system. So Unix was expensive, but we had technology that we could run these systems on, but hobbyists wouldn't be able to use or to afford something like Unix. So Richard Stallman began work on GNU as a way to provide this open source version of Linux, or open source version of Unix rather. And then in the early 90s, Linus Torvald came around and wrote his own kernel that was consistent with the Unix system and could combine all these components from Stallman's GNU project to create a new operating system called Linux, which is now one of the most widely used pieces of software in the server world and in the vast majority of supercomputers in the world. So this has had a real impact on technology and information technologies and the internet infrastructure. As of June 2014, we see that 97% of the world's fastest computers, or the world's 500 fastest computers rather, use Linux as a primary operating system. And large organizations like the DoD rely very heavily on the sort of free software and open source software. So that's sort of the history and background behind why open source software exists. But remember, all of this is to provide a legal means for an author or content creator or software developer to say, I'm allowing people to reuse my content without having to ask me. But they have some restrictions about any sort of derivative work they make may or may not be governed by the same license. They cannot take my software and make it closed source, these kinds of things. So what do these licenses look like? The open source initiative has a breakdown of licenses that are popular. A few are here. So the Apache license, run by the Apache organization, is pretty popular. The BSD license, the GNU General Public License, this is Richard Stallman's one. GPL is generally what's called viral. So if I release a piece of software that's GPL'd and you make a derivative work on it, you have to comply with the GPL, and all of your derivative works are GPL'd. Whereas something like the Apache license is not so strict in this way. And there are other ones like the MIT license and a few others. All right, so the open source licenses I just listed were really about software. They were addressing a fundamental issue with software. We wanted to make software more available, more accessible, and allow communities to engage with pieces of software. But software is not the only kinds of things it's not the only kind of thing that gets copyrights. So the Creative Commons licensing came around as well. So while we have open source licenses for software like Git or Drupal or MySQL or WordPress or Linux or all these things, we also need to do something for art, to make art and creative content like that also accessible in the same kind of way, where a content creator who's creating new art or new fiction, new literature can apply some license to their content so other people can use their content as well without having to ask permission. So this is where the Creative Commons license came from. Because right now, or without the Creative Commons license, there are a number of restrictions on how people can reuse your content. Because when you create a piece of content, things that are eligible for copyright become copyrighted at the moment of inception. So basically, if you have some story in mind, the moment you write it down, the moment you tell it to somebody, you now own the copyright to that piece of content. You don't have to do anything, it immediately happens. So if somebody were then to try and reuse that piece of content, they could be liable for violating your copyright. Now, in some sense, that's good. It allows people to maintain control over their work. But on the other hand, if you want to allow people to use it and have some sort of control over that allowance, then there wasn't just a very easy mechanism for this. So the idea of the Creative Commons came around to address these issues, that you have to contact people before using their work, And just because somebody has posted a piece of content on a website or something without any licensing notice doesn't mean that you're free to use it. Same way with if I post a piece of code on GitHub and I don't have a license statement associated with it, you cannot just use it without consent. You're supposed to ask me for permission. And the issue with this is, especially with something like creativity or art or design, always requiring people to ask for use or ask for permission to reuse something can slow down the creative process. So the Creative Commons license came around to allow you to address these kinds of issues, especially when existing art may be very expensive. So by streamlining this, by providing this Creative Commons license, basically says the Creative Commons license allows the content creator to say, all right, here are a set of uses where it is okay for you to reuse my content without contacting me. And here are the rights that I retain as content creator. And that way some random organization or individual can't then claim a piece of content that I've created and then create or claim their own copyright on it. I still have some amount of control without requiring people to ask me for permission. So probably one of the largest repositories of Creative Commons content is Wikipedia and the Wikimedia Commons. So anything that's on Wikipedia is governed by the Creative Commons license in some sense or in some way. So you can take content from Wikipedia and you can put it into you can reuse it for whatever you want, but you can't monetize it. You can't claim ownership because it's bound by the Creative Commons license. Also, the Wikimedia Commons is a place where people can upload images or music or any kind of content, and also goes under the Creative Commons license. So I encourage you to go check out Wikimedia Commons because there's a huge amount of content there. If you're looking for images or audio to use for something, there might be a large collection of that kind of content there. Places like Flickr and Shutterfly and other places as well also support Creative Commons licensing. So when you upload your images to Flickr, for instance, you can specify the kind of license that you want. And there are different flavors of the Creative Commons license. So you can say there's an attribution license. People can use your content as much as they want, as long as they tell other people where it comes from. There's attribution and no derivatives. It says people can use my content, but they can't modify it. They can't take an image that I've created and then modify it without my permission. And then there's a third version. There's attribution plus no commercial use and no derivative use. So you can say people have to say this content is by me, and they can't use it for financial gain. They can't use it for like their own logos, but they can use it in art or for slides or in presentations, these kinds of things, but they can't modify it either. And you can mix and match, so you can do attribution plus no commercial, or attribution plus share alike, or attribution and public domain, these kinds of things. And then there's the generic, so an example of this is the generic version that requires attribution. This is like one of the most simplistic, where you are free to use a piece of content. You can share it, you can adapt it, you can remix it, transform, but you must give appropriate credit and provide a link to the license and indicate if any changes were made. So what I've just provided are a collection of methods that provide exceptions to the general kinds of control you get from intellectual property protections. So remember, the first one was about fair use doctrine. So you should be able to describe what fair use is and why it exists. Then we talked about open source software and open source licensing. So what is the goal of open source licensing? What is a goal of open source licensing? And then we talked about Creative Commons. So all of these are basically ways where people can reuse or modify or engage with existing content that could be copyrighted without having to ask permission, either because with the fair use doctrine, there's a specific use involved that is an exception for existing protections, or with open source software and the Creative Commons licenses, it's because the author has provided you with that permission beforehand in a legally rigorous way. All right, well, that's the end of this class, both in terms of lecture and in terms of the class overall. So that's it. I hope that this class has been beneficial for you, and that the main thing you take away is that the world is complicated and we need to think carefully and conscientiously about how we engage with technology and how society uses technology. So thank you very much for being involved and being a part of my class this semester. And remember that over the next couple of weeks, you still have to work on your final report and on the discussions that people are posting in the student presentations and whatever discussion questions I've posted for week 14. All right, thank you very much. And I guess I will hear from you all when you send me your final reports.